Good morning. Today is June 4th, and our agenda today is going to be talking about the agency law. We'll touch a little bit about the NAR settlement and some of those upcoming changes that we're going to see later this year. And in talking about that, I am going to be referencing Form 41 and the listing agreement Form 1A. I'm not going to be pulling up a specific form and doing a line by line in this, but rather a conceptual idea of exactly how the agency law affects us and what we need to do and say and make sure we are portraying to make, to let our clients know our true sort of position in who we represent. So we will be talking a little bit, like I said, about the agency law. I'll be bringing up some MLS changes that are going to be happening in August. And the only reason I'm bringing these up is because I truly believe that if we start practicing now on how we are explaining things, it's going to be a very seamless transition. So I would love to see us be ahead of the game when it comes to things like this. I'm going to talk about some of the agency law changes that have happened this year specifically. Not necessarily the changes that have happened, but exactly what it means to be an unrepresented buyer or a limited dual agent. We will talk about who do you represent. So I'll bring a few scenarios to the table and we'll be able to kind of think those through together. And then talk about the agency duties that we will be giving our clients when we hold these different positions. So as we all know, the NAR settlement is going to be effective with all of their settlement agreements as of August 17th. So as of that date, all the requirements are going to be in full effect that have been agreed upon. The upcoming changes that we are going to see specifically are that everybody has to have a written agreement when touring a home. Guess what? We already do that. So we're already ahead of the game on that. Also, you must identify the broker compensation as a fixed number. So this means no more of the pay as offered. This is not going to be able to have a range. We're going to have a specific set number. Brokers will not be allowed to receive any compensation over the amount that they've been agreed to. And I'll discuss that a little bit more in detail as we go further down these slides. And then we also, again, we don't do this, but we also need to make sure that we are never saying that our services are offered for free. Along with this, that we've been accustomed to since 2019, there is a decoupling of the compensation. So that is just going to be something that is even more prevalent and more, I don't even want to use the transparent word, but it's going to be very, very apparent when somebody is signing that there are two separate compensation offers, one to buyer, one to seller. They are not in any way connected. Compensation must also be known that it is negotiable. Although as a brokerage or a firm can create policies to have a minimum amount if they choose. As a general whole, though, the policy is that this number has to be something that is considered negotiable, and the public needs to be aware of this. And then sellers must approve any sort of offer to a buyer broker for their compensation, which is what we use for our listing agreement. So we know in Washington, we've been ahead of the curve. The Northwest MLS has really put into action a lot of these requirements in advance. So we're already used to some of these practices that the rest of the country is going to be kind of shocked about. We also have to keep in mind that our MLS doesn't cover the entire state of Washington. We have several MLSs within our state. So although we in the Northwest MLS are a broker-owned MLS, there are NAR MLSs within our state. We might be in areas where we may do business with people who have to abide by the NAR settlement rules. So knowing them is important, but dwelling on them is not, because we are not directly a part of it. So as part of the requirements, what we've done, of course, is we have created the buyer broker service agreement, which is the Form 41. We have made it very, very clear that the compensation is negotiable. It says it on the 41. Now, when they update the forms in August, they're going to make an even more obvious clause that says that that is a negotiable term. So we'll have that slight change coming up. We do have statewide forms that name compensation for buyer as buyer broker, and we have forms that make everything very, very clear for us. So creating our agency relationship is basically the focus of where all these NAR changes are, right? We need to actually create this relationship, create our obligation to our clients, and then follow through with what those duties mean to us. So step one in creating our relationship is going to be explaining what it actually means. And we have in our possession in Washington, the real estate brokerage in Washington pamphlet, or the P1, that gives the breakdown of what this relationship means. It lays out the duties we have to the buyer and seller, or even as a limited dual agent. So why is this so important? Well, think about scenarios where we may find ourselves hosting an open house, maybe talking to a buyer or talking to a seller or a potential buyer who comes in unrepresented. You know, we need to put ourselves in those mindsets that if we represent a seller, we have to remain loyal to our seller. If we represent a buyer, we have to remain loyal to our buyer. And unrepresented parties don't have loyalties at all. Dual agent parties have more of a facilitation, not really any advocacy. So our duties and services we provide will depend 100% on the relationships that we have with those consumers. All consumers get the pamphlet, whether or not they are represented. We want to keep this form basically on speed dial and always be prepared to hand it out. We need to have some sort of provable form of delivery. So ideally, initials on the form are fantastic. Other options for delivery could be something like an email with email confirmation of receipt. A read-only and transaction desk actually has a way for them to open up the file, and it shows you that it's been received, validated, and opened, just like a signing. It'll also stamp the acknowledgement. So what do we do? How do we know who we represent? I would like to kind of bring this back to like the basics. There are a few basic rules when thinking about who we represent. If we have a buyer agreement, we represent the buyer. If we have a seller agreement, we represent the seller. And in the event we are talking to somebody who we have not yet made an agreement with and not anything has been written up, there's no contract in place, no purchase and sale, we have to keep our mindset in the representation of a buyer. So we're still buyer heavy on this, but still required as soon as we start providing our real estate services to have that written agreement showing who we represent. Now, supervising brokers of any kind, if they are part of the contract in the same firm as another one of their agents, are going to be served as a limited dual agent. This is going to be specifically for your managing broker has a listing, they represent the seller, and somebody under their supervision is bringing the buyer. That managing broker would be a limited dual agent and would need consent in that situation. Now, if a managing supervising broker is overseeing somebody who represents the buyer and somebody else who represents the seller, they're a limited dual agent, but in a different capacity that doesn't require a separate consent. Any person holding a broker's license, like a real estate license, is going to technically represent a buyer without a signed agreement stating otherwise. So if you have a licensed TC, then that does represent the buyer by default. If you have somebody on your team who holds a license, who's going to be providing services to this buyer or seller, just keep that in mind. Because as a default, the buyer is represented. So if it's not a default situation where you have a seller you're working with and you have an assistant who is licensed or somebody who is remaining in contact with them, you're going to want to disclose the relationship between the two of you guys and define that. If you keep these basic rules in mind, you'll have a better understanding of how it works when you do get a client, and more importantly, what your duties will be to not cause detriment to the party that you do represent. So let's take a closer look at maybe some examples. Here's a fact pattern here. Agent A has a listing and needs another agent to host an open house. Agent B agrees to host the open house. While at the open house, a potential buyer walks in and likes the home. As agent B and the buyer talk, some negative things come up, and the buyer decides they would rather offer on another home they had previously just seen. The buyer has no buyer agreement, so agent B offers to take the buyer back to that home they previously saw and writes up an offer. Did the agent on site act accordingly to their agency duties by talking badly about the house? And who does the agent hosting the open house represent? So if you think about this, the agent who was hosting the open house did not have a listing agreement signed and did not have a buyer agreement signed. So when you think about kind of the default rules, that agent in all senses was supposed to be acting on behalf of a buyer. The site agent did nothing wrong, right? They represent the buyer by default. Now, this representation by default doesn't award payment or the right to continue to look at houses. It's not that we can just ignore the duties that we have to fill out that agreement stating that very specifically, but because of who they were talking to in the capacity that they were talking to them in, they did nothing wrong by convincing that buyer to buy a different property. So how would you write this up to create an agreement with that buyer and more, basically define your role? Well, you'd want to make sure that when you do start looking at other houses and get prepared to write up an offer, that you have a conversation with that buyer and get your buyer agreement signed. Okay. A friend of yours loves their neighbor's house. They ask you to contact the neighbor and ask if they'd be willing to sell. The neighbor says yes. You write up the sale. Who do you represent? So there's neither a listing nor a buyer agreement signed. Who do you represent? How do you do this in a way that ensures proper disclosing of who you represent? So this is really similar to the last question. And we do need to remember that by default, we would represent the buyer. So approaching a potential seller, we need to keep that in mind. It has definitely been a realistic scenario where we've maybe approached a seller on a buyer's behalf, and then that seller decides, they want to disclose a bunch of stuff to us that maybe they shouldn't have said. So make sure you are communicating that to a potential seller if you truly do have a buyer. Also, with this scenario, we need to remember that we do have a limited license to practice law. So this limit is basically to fill out the Northwest MLS forms. We are not allowed just to write up a contract unless we have been providing some sort of real estate service that resulted in this sale. So in this situation, you would definitely want to do something before you write up the sale that shows you have provided a real estate service of some type. Now, whether that be to arrange a tour, show the buyer, write up a CMA, advise that client of yours how to kind of navigate through this contract, explain the buying process. There's a number of things we can do to provide that real estate service, but we are not going to be just picking up a pen and paper and writing up a contract. You'd also be required to obviously enter your buyer broker service agreement before writing up this contract. So once you've done that, you are completely within your license to write up the sale. Just remember, we don't want to simply just take some paper and write up our contract. Our insurance actually won't cover us for anything like that. All right. Here's one more. A buyer walks into your listing during an open house that you are hosting and wants to write up the offer now. Who do you represent? And how do you write this up in a way that shows this? So in our scenario here, it is your listing. Therefore, I'm going to assume you have a listing agreement. So you do represent the seller. Now, a buyer walks in and wants you to write up the offer now. The buyer is currently unrepresented. And if that buyer chose to remain unrepresented, then what you would do is you would write it up representing seller only. The buyer column would be blank underneath. And this is kind of an odd one, but you would write up, you'd also have to change, obviously, the way the compensation was being written. Now, if there's no, we'll go into detail on 41C in another class on how to write up unrepresented, how to look at dual agency, because remember what defaults in that line is going to be what the listing agreement says. Now, we are required to enter into our broker service agreement as soon as possible. So what does that mean? And thankfully, the meaning of this is very undefined. And I say thankfully because there are so many different scenarios that put us in situations where we can't always do it X number of days before we do something else. Our lives are ever changing when it comes to real estate and how we meet people. But the idea is with this, if you want to, in order to negotiate your pay, you need to actually create an obligation for that buyer before you negotiate the pay. So your buyer service agreement is essentially a contract between you and your buyer obligating them to pay you. And when you have that obligation to pay you, that means you do have the right, as decided in this contract, to ask for that seller to maybe help your buyer with their obligation. So again, each firm is different. Each office is going to have their own policy, but sooner than later is ideal. And definitely before we're starting to write up a purchase and sale, I think it would be realistic to say that by the time we put pen to paper with purchase and sale agreement, we could also have had the buyer service agreement signed. Now, if a contract is written the same day or the same meeting as your buyer service agreement, you're welcome to do a timestamp. If you just need to show the order of operations, make notes as to, this was signed over here and this was signed over there. And as of August 17th, we're going to be required to have a specific number when it comes to this form right here. So this is the Form 41, the buyer service agreement. So when it comes to the compensation, we're going to be required to have a number in here. There is not going to be the ability to write in a range. The number in here is going to be the number the buyer is on the hook for, which is the same thing that's happening right now. This number is the number that the buyer is on the hook for. We just have the ability on the next page to negotiate other options or other outcomes. We are still going to have that ability, but we will not be able to put a range in our buyer service agreement. We're going to have to use a 41A, which is the modification or the amendment to your buyer agreement to change anything that's already been put in stone. So another change coming in August that we need to be thinking about when we talk to our buyers is they're going to be removing a few options when it comes to what we can do with compensation offered more than what we've agreed to and compensation offered less. Essentially in August, they are going to be removing the option of having it come back to the firm. So the number you put in is going to be your number, and what happens if it's over will be an option of it'll go to buyer or it will go to seller. So please keep that in the back of your mind when you're talking this through, because how we say it now is going to affect how we say it later, and we should get used to knowing that this is coming. Also, when you negotiate in your compensation, we need to keep in mind part of our agency duties says that we are to take no adverse action towards our own clients. So if you have put in your compensation line that you're willing to take X amount of dollars, and then you go to negotiate, you are not allowed to negotiate above and beyond for your own pocket additional compensation that is truly to the detriment of your own client. So whatever number you put in there is the maximum amount of compensation you're allowed to receive. Now, I'll go back to this one again. If you put an amount in this and you are able to negotiate higher with the intention of putting that back to your own client, then you're not working in an adverse way to your own client. You may be working to their benefit depending on situations. So that's going to get more defined when it comes to the form changes coming down the line in August. I'm sorry, I'm going to go back to this one. There we go. So let's take a look at the listing agreement now when it comes to this. The listing agreement is going to have our listing compensation, unrepresented buyer. When you talk about representation and you talk about your agency duties, we start our conversations with things like, as your agent, here's how I'm going to represent you. Here's what I'm going to do for you. I am going to be giving you expert skill and care. I am going to be working solely for your benefit. I will be doing nothing that is to your detriment. Everything I do is going to be for you. So when we talk about things like that, we also have to keep in mind, if we have a buyer who chooses to be unrepresented, they are not going to get those benefits. So what does that mean with an unrepresented buyer? And as a seller, do you want to put yourself in a situation where you may have a buyer in that capacity? Think about what it means for that specific unrepresented buyer. Think about what it means for your transaction. Is the acceptance of an unrepresented buyer going to potentially be adverse to your seller? If you represent the seller and you take on an unrepresented buyer, is that causing more harm to the seller, or is it not? And I'm not going to answer these, but these are just things that we need to be thinking about, because as we fill out the listing agreement, part of our job too is to protect our sellers. And how are we going to do that? We're going to bring them offers that are to their benefit, with excellent terms, with competent people to pull them through. And we want that sale to go from start to finish. That's our goal for them. We want to get them the most amount of money with the best offer, with the best terms. So how are we going to be taking that action that might be best suited for our sellers? And those conversations may arise because of the idea that unrepresented buyers only get this much and represented buyers get this much. So we want to create that smooth transaction. We want to have the competence, skill, and care all around. We want our oiled machine to smoothly take us from start to finish. And think about if you've ever worked with an agent that was maybe a terrible communicator, or somebody who just didn't know what they were doing. It is incredibly difficult. And it's incredibly difficult as a seller. And imagine if there's one broker, even as a limited dual agent, who's taking care of that kind of thing in a capacity that doesn't benefit either person. So going through this compensation, have these talks about what each of these lines mean, and bring it back to our agency duties and what a listing broker does and what a buyer broker does, and the limits of a dual agent and the non-existence of anybody for an unrepresented buyer. Talk to your seller, and that may help them kind of figure out how this works as a big picture. So looking through a different lens, we need to just remember licensed brokers providing real estate services to clients are required to be disclosed. So this means if you have like an agent who is willing to open a door for you and show a home, they should be disclosed in the purchase and sale agreement as somebody who did provide real estate services for the client on behalf of them as a representative of them. Now, brokers working in that limited capacity are not necessarily going to follow through with the rest of everything that their main, principal broker, I guess, does. They are not going to be following through the transaction. It was just, I'm helping out today. I'm not helping out for a fee. This is just me. I'm just opening a door. But the disclosure of that is important, because during conversations, especially if it has to do with home inspections, we need those clients to understand, and we need agents to understand, if there are times where we are working inadvertently to the detriment of our own client, we are in fact like breaking our agency duties to them. So just make sure that we're disclosing who we are and talk about what that means. So, and as part of the settlement for NAR, we are required to decouple the compensation. And like I said, we've been doing this since, I think since 2019, October of 2019. But I wanted to color code this to just help give a visual of what that decoupling actually means. So we have two sections here. We need to look at this as two separate offers of compensation, right? So section A in the green is one offer of compensation, and section B in the pink is a different offer of compensation. As the listing firm, we are going to have X% or X amount of dollars for us as the listing agent. If the buyer is not represented, then the amount shall be the total amount that the listing broker is going to receive. Are you going to receive the same amount of money? Are you going to receive more money for an unrepresented buyer? Think about the things that are required of you as the listing broker to continue through a sale where you have an unrepresented buyer. You are still going to be required to keep communication, operate honestly, but you're not going to be advocating for this person. So your advocacy is going to remain with that seller. But just keep in mind, there are extra things you will be having to do. We want to make sure that we are disclosing who we work for with that unrepresented buyer, reminding them that we have told them to get representation, and also advising them that they will not be getting any of the following services. You will not be getting A, B, C, D. Go ahead and list them out. Now, when it comes to buyer broker, the first line is the percentage or the price that you get as a buyer broker. So that will be buyer broker gets X amount of dollars. Now, if the listing broker is both the buyer and the seller, working for buyer and seller as a limited dual agent, this number is what that listing broker gets, but as a buyer broker. So this is still the buyer side of the whole dual agency. This number is not going to be added up to anything. The number you put here is what one side will be, and the number in the green is what the other side will be. Now, if you're dual agent and you have that contract signed, you get A plus B. So we just need to keep those separated because we have in fact decoupled the commission and we are no longer adding numbers together. So let's recap some of our basic agency rules here. You represent the buyer in situations like a FSBO, or if you have a buyer agreement, or if there is no written agreement. You represent the seller if you have a listing agreement, or if you have a seller representation agreement. You will represent an unrepresented, there's no representation, sorry. An unrepresented buyer has no representation if they come to you as a listing broker, they want to write up a purchase and sale, and they do not want to sign a contract having representation with an agent. Limited dual agents are going to be managing brokers, anybody who is a team leader, managing broker, an overseer, any broker who oversees other ones. Designated brokers, if you have your own listing and somebody from your firm represents the buyer, that is dual agency, and obviously the flip on that. Now, this is only, keep in mind, this is only if that overseeing broker actually has a listing agreement or a buyer agreement and is part of that contract. The consent required for limited dual agent is only for a true limited dual agency relationship. If you're a supervising broker and not directly involved in the sale, just a representative of the firm. So say I am a managing broker and two of the agents in our office here decide to write up a sale. One represents buyer, one represents seller. I, by default, am going to be a limited dual agent in that capacity, but that does not need extra disclosure. There's no additional consent required. It is one of the clauses in our agreement. So keep in mind of that. It's also not necessary to cross that out, not necessary to get consent for that. If you have trouble explaining what that means to a client, please reach out to somebody and get help with having them understand that. This is something that happens very, very frequently. And I don't want buyers or sellers to walk away thinking that they're going to be a special situation and it's going to be a bad thing for them to do this. We do have a lot of that happen, and it's by default sometimes. So let's just make sure we are accurately disclosing all of these things because, like I said before, our agency duties line up to who we represent. And remember always, as limited dual agents, you are going to facilitate, not advocate. So if you're in a situation where that is possible, then maybe that's for you.